No, not yet. Yes, you can?
Yes, I can, yes.
Okay, I've just been introducing you, so you have the floor for about 20 minutes for your presentation.
Thank you so much. I hope I am not speaking too loudly. I have never used this platform, so I hope everything is fine. You can hear me fine. So let me start by thanking Panos and Sotirios for putting together this workshop and for having me. It's really a privilege to be with you. So I will try to make an efficient use of my time. As you know from the program, I will be talking about the changing authority of what is called in international law authentic interpretation. And the question I'm going to address is whether, in light of some important recent developments, the joint treaty interpretations are controlling or not. Now, I have to start with a caveat. I think everyone talking about treaty interpretation with that caveat, because there is so much that has been written about treaty interpretation. So there is a sort of burden on any speaker approaching the topic again to justify what is new out there that can be said about treaty interpretation. But I think this topic is peculiar, the one I am going to address, in the sense that most discussions in the discipline about treaty interpretation are mainly about the ways treaty interpretation should be carried out, what rules should be applied and used. And we have very few discussions and thought dedicated to the issue of what actors actually get involved in treaty interpretation and what kind of authority they can claim. So it's this latter aspect that is going to basically be the focus of my presentation, and more specifically, one specific actor, the treaty parties. We know that the parties to a treaty have the possibility to offer an interpretation of that treaty, and they make use of that possibility from time to time. An important question that arises is, what is the authority that jointly offered interpretation can claim in the discipline? Now here I claim that this is basically my argument, that an important change has occurred over the last few decades, I would say, culminating in the position of the International Law Commission in the context of its work on subsequent agreements and subsequent practice in relation to the interpretation of treaties, namely a point made in the commentary, not in the conclusion, that joint interpretive agreements are not necessarily legally binding. Now, I talked about change, why I am so confident that this is a change. The reason why I feel confident is that if you go to some major classical statements of law having to do with this specific point, ranging from Oppenheim's International Law to Max Planck Encyclopedia or Public International Law, the conclusion that was offered that you will find out is radically different. There was a tendency to take it for granted that if the parties offer a joint interpretation, that's basically the end of the matter, and it can't even be debated or discussed, and third parties, including international adjudicators or national judges, are necessarily bound by it. Now, basically what I'm going to do in the remainder of my time is to account for that change with a particular conception of authority that I am going to outline in a moment, I think it's important to have that conception of authority in mind if we want to understand what is happening here. So very briefly, I can't be too long actually on this point. There are a lot of conceptions about authority out there, and most of them are vulnerable to Michel Foucault's famous charge that political philosophy still needs to cut off the king's head in its conceptualization of power relationship. So basically, Foucault's point was that political theory was still too much obsessed with prescriptions and prohibitions, and basically it was accounting for authority relations in terms of some ultimate source, the person of the king or other similar alternatives. Now, there have been some attempts recently to move away from that model, but I think what we see mostly out there is still a major focus on authoritative figures in the form of persons, offices, and institutions. The conception I'm going to rely on is a theory of authority offered by a sociologist and political scientist in 1980s. I find it incredibly underrated and also probably not that well known. So the authors are Kim Shepperly, who is a sociologist, and Carol Sultan, a political scientist. They propose to go beyond the actor-focused conception of authority. And here's a quote, which basically summarizes their view of authority. Authority is not simply the right of actor A to get actor B to carry out A's will voluntarily. Instead, authority is found when actor B finds compelling particular properties of A. Authority is constituted not by person A willing a particular state of affairs, which is then carried out, but rather by person B being attracted by the state of affairs offered by alternative A and voluntarily choosing that option over others. I find this conception of authority quite compelling, especially in the context of international law, where we don't really have hierarchical power structures. And one thing I will focus on here is the concept of attractiveness, basically attractiveness as a ground of authority, an option becoming compelling and attractive, not because there is a force behind it supporting it, but because it looks or appears attractive to relevant actors. And one element of attractiveness, which is, by the way, put forward by the authors I just mentioned, is obviousness. Basically, and this is also a quote, the intuitive appeal of a particular solution for a particular problem. So if an option looks obvious, it will carry out authority, even though there is no, let's say, institutional verdict or decision consecrating that option officially. Now, why is it relevant to my point? The reason why I find it relevant has to do with traditional state of affairs in international law that made the joint interpretation by the treaty parties attractive. I will go to some of them in a moment. The first option is, of course, international law has traditionally been state-centric. So states were not being considered just one actor among others, but as a pivotal actor around which the entire discipline of international law revolved. So, of course, states were not seen as only the addressees of international law, but also as the makers of international law in that traditional understanding. And it's, I assume, relatively straightforward to say that one implication of that paradigm, basically a state-centric paradigm, was that states should have the final say with respect to the right meaning of, or the accurate meaning of the treaties that they had put together. So this is one element of obviousness. Why it looked obvious to us? Because the whole system was relatively state-centric, and we had basically led to believe that that alternative is attractive. The second element I want to highlight has to do with the lack of plausible alternative. Again, if we take classical international law as our basically object of study or analysis, and what were other plausible alternatives in the context of classical international law? So international law classically was a matter of intercourse among chancelleries involving no third-party adjudicators, no non-governmental organizations, or no third-party beneficiaries. So of course, treaties were transactions primarily affecting and concerning states, and in that sense, the point that states should have the final ultimate say about the interpretation of their treaties also looked obvious for that reason. And one last element explaining the obviousness has to do with the treaty interpretation regime. We know, even though with the Vienna Convention on the Law of Treaties, things have changed slightly. I will come to that point in a moment. More than slightly, I should say. Treaty interpretation has been traditionally linked to the common intention of the parties. We know, in terms of the intellectual history of treaty interpretation, we know that there were commentators, Herschel Lauterbach was one of them, who were actually skeptical about the utility of rules of treaty interpretation, provided that for them, the basic rule of treaty interpretation that interpreters should basically give effect to the common intention of the parties, and how they identify that common intention is basically a relatively open question, even though there may be some guidelines with respect to that point. Now, as I said, that situation has changed with the Vienna Convention on the Law of Treaties, but we still have that discourse, right? For instance, in the context of WTO, we have plenty of decisions by the appellate body saying that the point of treaty interpretation is to give effect to the common intention of. Now, if we take that paradigm seriously, common intention of the parties, there is this concept, I think it was popularized by many writers, paradox of knowing better. So how a third party can claim that it knows the common intention of the parties better than the parties themselves. So if the parties have come up with a joint interpretation, it should be trusted, obviously. Why? Because they are supposed to be better positioned than third parties to identify or to relate or convey that common intention. Again, the premise here is that you operate on the basis of the common intention paradigm. Now, I mentioned earlier the change. Basically, every single of these grounds has gone through a significant change. Let's take, for instance, the first one. I mean, it's a relatively let's say straightforward point that international law is no longer state-centric. There are many actors alongside states participating in the making, in the enforcement and adjudication of international law. So we no longer have that obviousness associated with the state-centric nature of international law. Another ground I mentioned earlier had to do with the lack of alternatives. We know that there are a lot of alternative interpreters these days. Basically, states have competitors in terms of if we can use the metaphor of market of treaty interpreters, states are not the only actors, right? We have international judges, we have national judges, we have non-governmental organizations offering, we have treaty bodies, expert bodies offering their own interpretation of treaties. So obviousness in that sense has also been undermined or challenged seriously. And the last ground I mentioned, treaty interpretation regime, earlier I said that the Vienna Convention has brought a significant change with respect to this matter, and that change has to do with basically not the exclusion of intention, because the intention is still mentioned in the Vienna Convention, Article 31, Paragraph 4, contrary to what some commentators suggest, intention is not excluded, but that's not the official treaty interpretation doctrine, right? Official treaty interpretation doctrine is that treaties should be interpreted on the basis of the ordinary meaning of their terms in good faith, in light of their context, etc. Now, if you think about it, I made the point earlier that if your paradigm is the common intention of the parties, it's very easy for states to tell the audience that they are best positioned to convey that common intention. But the situation is radically different if the object, what we are looking for is not the common intention of the parties, but the ordinary meaning of the terms. It's very difficult, from a purely rational standpoint, for states to claim that they are best positioned. Other actors may be at least equally well positioned, third-party adjudicators, actors with some interest in the subject matter and expertise, etc. So this is basically the heart of my argument. Now, I will say a few words about how the International Law Commission went about it, but that's more about the mechanics rather than, let's say, the foundational aspect I just referred to. So the way basically the National Law Commission went about it is, first of all, of course, we should ask ourselves, how was it possible for the National Law Commission to say such a thing? As you know, the Commission works very closely with states. The Commission interacts very closely with the Sixth Committee. The Commission invites states to provide comments and observations about its work products. So how such a thing, how the Commission was able to get away with such a change? So why states would be fine with accepting that their joint interpretations may not necessarily be legally binding? Now, there are several explanations I can offer, but in the interest of time, I will just focus on a couple of them. I think one of them has to do with the fact that even though as international lawyers, or most international lawyers, would feel confident that until very recently, let's say the disciplinary consensus was that joint treaty interpretations were binding, there was no formal rule stating it. There is nothing in the Vienna Convention clarifying that the joint interpretations are binding. And there is no precedent, at least to use the word authoritative precedent making that point. There is a famous case by the Permanent Court of International Court of Justice, Gavorgina case, but that's not really about treaty interpretation. even though it's a case that is cited for that proposition. And the International Law Commission in 1960s, when working on the draft Vienna Convention on the Law of Treaties, made some points in the context of the commentary, basically making the point that joint treaty interpretations are authentic and should be read into the treaty, but they were put forward in the commentary and not in the draft convention itself. So it was, let's say, not necessarily easy, but at least it was possible for the International Law Commission to make that move, because the Commission probably didn't feel that they are basically revisiting, let's say, a firmly established, well-settled rule of international law. So basically, the Commission was able to convince many interlocutors that the matter was unsettled. And I call it in the paper discursive construction of unsettledness. So basically showing, I think, I am going to be frank here, by selective use of authorities. For instance, the Commission never mentioned there is the only monograph dedicated to the authentic treaty interpretation is actually a PhD dissertation defended at the Graduate Institute, my home institution, where the author makes the point that authentic interpretation is necessarily binding, and that book is never mentioned, for instance, in the Commission's commentary. And the Commission also marginalizes the weight of authority going in the other direction by saying some commentators say this, even though those commentators carry much more weight than the ones actually the Commission relied on, including the Special Rapporteur's own work, which I find a little bit circular. But that was one way of doing it. Another reason, and I'm going to stop here in the interest of time, had to do with the fact that states don't really engage, let's say, massively with the Commission's work for a variety of reasons. Some states don't have necessarily the legal expertise that would, or technical resources that would be necessary to engage with the Commission's work deeply, meaningfully. Some states make the choice not to engage with it because these are abstract matters. Maybe they want to keep their options open. So while the matter has not come up in a concrete instance, they feel they can wait and determine their position in due course. But whatever the explanation might be, one thing is clear in my view. It has to do with the fact that this position that has been put forward by the Commission is going to carry out a lot of authority, given how seriously the Commission's work is taken. I will stop here in the interest of time. Of course, I had to go very quickly on many points. I would be happy to go back to some of them if there is any question later. Thank you so much for your attention. Thank you.
Thank you very much, Fuad, for this interesting insight into the new questions that relate to treaty interpretation, particularly party interpretation. I'm pretty sure that there will be questions on some of the aspects that you raised. Let me first see, because let's do exactly what was done in the previous panel and see if there's any questions that relate to any unclarities that need to be clarified at this moment already. Which does not seem to be the case, and allows me to move on to the next speaker, Thomas Kleinlein. The floor is yours.
Thank you, Ramses. Thank you to Panos for inviting me. It's great to be here. When I think about the subject of this talk, which is change of peremptory norms of general international law, use Cogens, I feel a certain uneasiness. I feel privileged that I can now articulate the reasons for this here in this workshop. My unease primarily stems from statements that feature prominently in the use Cogens literature, two sorts of statements. While both of them are correct, meaningful, these two statements seem to me contradictory, if not paradoxical. On the one hand, scholars often assume that use Cogens is a class of norms characterized by a general resistance to change or relative permanence, or in my words, a particular stability and robustness. On the other hand, scholars also emphasize that peremptory norms, as the supposedly most important norms, are based on the most uncertain or even enigmatic mechanisms of norm change. So the question is, how can use Cogens effectively resist change if the relevant rules of change are uncertain? Or should it be the very uncertainty about how use Cogens can be changed that causes a hesitation to change it and thus provides for stability? This question is not at the center of academic interest, as we heard before, but it's of practical relevance. Some of the substantive or primary norms with use Cogens status are under pressure for change, not to say exposed to norm erosion. As you know, the annex to the draft conclusions on the identification and legal consequences of peremptory norms of May 2022 provides for a non-exhaustive list of norms that the International Law Commission has previously referred to as having the status of use Cogens. This list includes the prohibition of torture. We are all aware of the fact that especially the United States has been regarded as the most important actor in eroding the torture prohibition. For example, so-called no-touch torture was not only frequently employed during the war on terror, especially the United States has also engaged in a reinterpretation of the definition of torture. Attempts at this redefinition aimed at excluding no-touch torture from the definition of torture on the one hand, and at adding a special intent element, allowing the US to argue that torture to save human lives never constitutes torture in legal terms. The combination of change in the definition of torture and the introduction of possible justification of acts of cruel, inhuman, or degrading treatment was also undertaken by other states, inter alia by the United Kingdom and Israel. The ILC's non-exhaustive list also includes the prohibition of aggression. I do not want to make the point that the prohibition of aggression is under normative pressure. However, there is a considerable scholarly debate and also debate amongst members of the ILC as to the question whether only the prohibition of aggression or the prohibition of the use of force as such is of peremptory character. A vast majority of authors generally regard the prohibition of the use of force as such as peremptory, while others advance the position that only the prohibition of aggression constitutes. If we subscribe to the view that the prohibition of the use of force as such is peremptory, which I find more plausible, we are faced with a second example of a peremptory norm that is under pressure to change, or more precisely, to be restricted. We have already seen notable efforts to limit the scope of the prohibition of force, I would say the scope of prohibition of force, by extending the scope of self-defense to acts against non-state actors, by introducing humanitarian intervention as an additional exception, or by invoking the legality of forcible countermeasures in response to the use of weapons of mass destruction. Indeed, peremptory norms are not immutable, but of evolutive nature. This is recognized in Articles 53 and 64 of the Vienna Convention on the Law of Treaties, as we've heard this morning, expressly stated by the International Commission already in its work, by the International Law Commission already in its work on the law of treaties, and it's barely unanimously accepted, even though some doctrinal controversy exists regarding its source. As you know, Article 53, Sentence 2 of the Vienna Convention foresees the possibility of a modification of use Cogens. It reads, for the purposes of the present convention, a peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. Moreover, Article 64 on the consequences of the emergence of a new peremptory norm is obviously also based on the idea that use Cogens is not immutable. While use Cogens is thus in principle not immune to change, the claim that it is resistant to change or relatively permanent is also built on Article 53, Sentence 2 of the Vienna Convention, according to which peremptory norms can be modified only by a subsequent norm of general international law having the same character. This special character of use Cogens, however, provides the basis of resistance only towards certain modes of change and not all possible modes of change. Norms of international law can be subject to both formal and informal norm changes, as I would put it, formal norm changes being a matter of the doctrine of sources, and informal norm change happens through the shifting meaning of norm texts and is a matter of interpretation. So Article 53, Sentence 2 of the Vienna Convention has no obvious implications for informal norm change by interpretation and does not make use Cogens immune to interpretive change. This is obviously relevant for use Cogens contained in general multilateral treaties, but as we know, customary international law is also subject to interpretation. Accordingly, the claim that use Cogens is resistant to change as far as it builds on Article 53 and the special requirements for modification of use Cogens only refers to a particular mode of change, namely formal modification. This formal process of the emergence and also the evolution of or change of peremptory norms is a two-level process, at least in theory, as we have talked about this also this morning. According to the wording of the Vienna Convention, a peremptory norm must first become general international law, that is either customary international law or a general principle of law pursuant to Article 31 of the ICJ statute. And in a second step, it can be elevated to use Cogens by the international community of states as a whole. Accordingly, a change of a peremptory norm brought about by the emergence of a subsequent norm having the same character presupposes a new rule or primary norm of general international law plus an opinio juris cogentis that is necessary for establishing the special character of peremptory norms with all the consequences or secondary rules attached to it in the law of treaties and beyond. At least in theory, the primary norm first comes into existence in the same way as any ordinary norm of general international law, and so far no qualified procedure applies. If we isolate this first step, it would be a very difficult step if it conflicts with use Cogens, which has, of course, derogatory power. The ILC, in its work on the law of treaties, assumed that a change of use Cogens would most probably be effected through a general multilateral treaty. And here begins the blurring of the distinction between the substantive norm and its peremptory status. If a wide majority of states parties to a treaty providing law conflicting with previously existing rules of customary or conventional law, even if these rules were of use Cogens character, then it must be somehow assumed that the will of these states was to modify the old legal regime, even if it was use Cogens. Therefore, it has been argued in the literature that the stipulation of Article 53 is, quote, a quite strict requirement, totally unrealistic and incompatible with the traditional and still valid pattern of the lawmaking process in the international order. Modification of use Cogens can, of course, also occur as a result of subsequent custom. For this to be the case, the practice must also be accepted and recognized by the international community of states as a whole. state practice that becomes accepted and recognized by the opinion juris of the international community as a whole could possibly sow the seeds of a new peremptory norm. This is accompanied by a good deal of legal uncertainty, but given the high evidentiary burden, this process of modification through custom is also considered to be, quote, hardly conceivable. It is doubtful whether the special status of jus cogens norms requires a higher threshold for achieving the rank as opposed to the creation of ordinary international rules. Statements at the Vienna Conference on the Law of Treaties highlight that acceptance by a very large majority of states would suffice to establish the peremptory character of a norm. Yet the wording of Article 53 of the Vienna Convention on the understanding of state parties at the time reflects an unstable compromise found during the Cold War and the situation with a divided world. Therefore, some uncertainty persists with regard to the emergence and change of these cogens. Indeed, the supposedly most important norms are based on the most uncertain mechanism of norm change. Today, in its draft conclusion 7 on jus cogens, the ILC now says that acceptance and recognition by a very large and representative majority of states is required for the identification of a norm as a peremptory norm and so on. Yeah? Acceptance and recognition by all states is not required. So that is what they say, somewhere in between. The ILC also holds in conclusion 14 that a rule of custom international does not come into existence if it would conflict with an existing peremptory norm of general international law. And this is without prejudice to the possible modification of a peremptory norm of general international law by a subsequent norm of general international law having the same character. That's conclusion 14. Indeed, the existence of a peremptory norm will already deter the emergence of a customary obligation to violate them. General state practice will normally not follow a path that leads to patterns contradicting ideas of moral paramountcy. Yeah? According to the International Law Commission, jus cogens norms reflect and protect fundamental values of the international community. That's also a quote from the recent Cogens project. Thus, when a peremptory norm occupies the field, a contrary obligation can hardly develop under another norm. While here again, the theoretical distinction between opinio juris and opinio juris cogentis will be difficult to make in practice, it is to be noted that different from the creation of customary international law in general, the creation of the special status of a norm as jus cogens obviously does not depend on consistent state practice, but only on opinio juris cogentis, namely acceptance and recognition. State practice is irrelevant for establishing the peremptory status of a certain norm according to this. As said, the second sentence of Article 53 of the Vienna Convention defines a peremptory norm of general international law as a norm accepted and recognized by the international community of states as a whole, as a norm from which modification is permitted and which can be modified only by a subsequent norm of jus cogens. Different from the creation of customary international law in general, the creation of the special status of a norm as jus cogens obviously does not depend on a consistent state practice, but only on opinio juris cogentis. In its draft conclusion 8, however, the ILC lists as possible forms of evidence of acceptance and recognition, public statements made on behalf of states, official publications, government legal publications, and so on, plus conduct of states, which is again something like practice, I would say. But in any case, it is subject to debate whether the focus on acceptance and recognition instead of evidence of general practice accepted as law, which is the wording of Article 38 of the ICJ statute, leads to more or less stability, if not of the respective primary or substantive norm, but of the peremptory status. At least one can say that it increases the influence of states with less capacities to influence the relative actual practice out there in the world, and on the other hand, reversely decreases the influence of powerful individual states or groups of states, yeah, that have that special power or that special capacity. Apart from formal modifications through the emergence of a subsequent peremptory norm on the same topic, but with a different content that we were talking about so far, or I was talking about so far, there's also the possibility that states withdraw their opinio juris cogentis without building a new peremptory norm at the same time. In such a case, the requirement for use Cogens norms posed by the definition of Article 53 would no longer be fulfilled, and the norm would simply cease to exist as one of use Cogens. This would be a further mode of formal norm change, which is probably not to be excluded by Article 53, sentence 2. So modified in Article 53 should therefore be narrowly understood as to encompass only change in the proper sense of the word, but not extinguish or cease to exist. Yeah, that would not be modification in that sense. Here again, the reason why we can say that peremptory norms have a strong resistance to change is that use Cogens norms reflect and protect fundamental values of the international community. Based on what I've said so far, I think I can make the claim that there is a presumption against change that comes with the peremptory status of a norm. This claim has already been made by other scholars who write that the acceptance of change of a peremptory norm cannot be assumed lightly, that's the quote, or that the resilience to change inherent in the concept of use Cogens advocates for a conservative approach to interpretation, that's another quote. I wonder what this assumption against change is based on, what is its foundation. The resilience to change inherent in the concept of use Cogens is less a foundation for the claim of a presumption against change than a slightly less sophisticated restatement of this assumption. One of the scholars I quote also writes that the fundamental rule of pacta sunt servanda applies a fortiori to use Cogens. But pacta sunt servanda is not a satisfying answer to me either. In the end, I think that the core of the argument should be that rules of use Cogens lay down the most basic rules of a society, and that therefore drastic reversals of existing peremptory rules cannot be expected frequently and or rapidly. Accordingly, this presumption against change has less to do with the non-derogability of peremptory norms, that is their technical status, than with their fundamental character, that is their substance. Also in Article 53, sentence 2 of the Vienna Convention, non-derogability and modification only through subsequent use Cogens are two distinct elements of the definition given by the ILC. However, it's doubtful whether the latter part of the definition, modification only through subsequent norms of the same character, is really part of the definition. It's formulated like a definition, but most authors say that it's not part of the definition. That's also reflected in the work of the International Law Commission. So while this is doubtful, I think that the two, non-derogability and modification only through subsequent norms of the same character, are closely interlinked, because at the core they mean that individual states or groups of states cannot inter se, Latin inter se, I would say, pronounce it in English, break out or contract out of use Cogens. That's the core of the issue. Yeah. In this regard, we can also draw parallels to another presumption about use Cogens, which refers to its interpretation and application, and to the conclusion 20 that we were talking about this morning. I asked this question to Dira. In conclusion 20, the International Law Commission holds that there appears that there may be a conflict between a peremptory norm of general international law, use Cogens, and another rule, not only treaty rule, but another rule of international law. The latter is, as far as possible, to be interpreted and applied so as to be consistent with the former. So that's the latest stage of that formulation. I think that this implies some sort of presumption against conflict with use Cogens, and this is complemented by a presumption against change, which is based on the same reasons. However, it's still fair to say that it seems to be the spirit behind the letter of the very Article 53 of the Vienna Convention that the norms of use Cogens are not necessarily or exclusively the basic constitutive norms of the international legal system, but simply those rules which are considered by the international community at a certain point of time as having the use tokens function, even if they serve purposes limited in time and of no fundamental value for the social order of states or of the international order in the strict sense of the term. That's the very idea of the positivist notion in Article 53, if you take it like that. Another question that needs, of course, to be discussed is how a presumption against change and distribution of burdens of argumentation defined by this presumption can operate in practice and what they mean in practice. What would it mean to hold, for example, that the more an interpretation deviates from a more or less established understanding of the content of a peremptory norm, the higher are the requirements for the acceptance of such a modified understanding. So this would be maybe the formula for this presumption, but what would it actually mean in application? In any case, I think that a presumption against change, with its admitted vagueness, but nevertheless normative force, is a suitable doctrinal category to accommodate both the resistance of peremptory rules to change and the uncertainty about the relevant rules of change. Thanks very much.
Thank you very much, Thomas, for this. These insights, new insights even into the relationship between change and the peremptory norms. Some of us may become a bit nervous, including myself, if you try to talk about more flexibility. I've always thought of these norms as a sort of super constitutional norms, but we'll probably have some discussion about that later on. Thanks very much for this. Are there any points at this moment that need to be raised to clarify issues? Enzo?
So, Thomas, I immensely appreciated your presentation, but I must make a premise and then I want to ask a question. The premise is that I am among those scholars who quite sharply criticize Article 53 for being unrealistic, as you may know, perhaps. The question is, are you suggesting that the rule of change for use Cogens is based on acceptance and recognition of the rule as non-derogable? And if your answer were positive, my question would go on. This entails that the rule of change for use Cogens, fundamental, etc., the core business, the foundation, international law, the public conscience, is less demanding than the rule of change for ordinary customary law. And well, how do you explain such a pattern?
And of course, we will have a larger discussion later on, so you have just a brief question. And there may also be a question online, right? We're not hearing anything, or you're trying to get the slides on already? Okay, good. Thanks. Thomas, please.
Yeah, maybe the answer to the first part of the question is yes, it's acceptance and recognition, so it's basically the same mode for change. And then you have all that uncertainty that comes with that, and that is the paradox I started with. So that's the paradox I started with, and that was the reason for my uneasiness and so on. Yeah.
Satisfied for the moment?
For the moment.
For the moment? But I gladly give you the floor, Enzo, if you are. So here we are with visible slides, which is always a good thing. And I'm very happy to welcome Enzo Cannizzaro to Groningen for the second time already this year. Enzo, and probably not the last.
So, first time in my life and twice here. So thank you very much. I'm very happy to be here. Also because the organizer of this conference accepted my main claim. I will accept to contribute to this workshop, but I want to be chaired by a dean. And I expected the dean, but I'm the vice dean and must be happy with him.
Sorry.
So my presentation will concern how customary law evolves through conflicts. And I will make a number of possibly heretical propositions. I do so in the genuine belief that we were a small group of people. I didn't consider the larger audience which is hidden, but follow our works. And well, I apologize for every heretical proposition I will pronounce. So, for sake to not have the time to explain everything, every articulation of my thought, I think it's proper to state the main passages of my speech. First of all, I will engage with the classical doctrine very briefly. Second, I will propose my own quite naive conception of custom, very briefly. Well, not necessarily new. I held such conception for years, and I express in some writing, mainly in Italian, but also in English. Third, I will present conflict as a driver for the development of international law. And fourthly, if I have the time, I will present an experimental case study on the relationship between Article 51 of the UN Charter and Article 1 articles on the state responsibility. So let me go to my main critique to the classical doctrine of customary law, and this is the first one. I always had problems of conceiving of customary law as a unitary source of law. Of course, all customary rules have the same effect, but the process of formation and the legal dynamics they entertain with other sources of international law may change very fast. The classical doctrine consists of customary law, structural law, behavioral law, but doesn't inquire what there is behind behavior, how this behavior and why this behavior. To cure, a certain sense, to remedy my weakness with classical doctrine, I think I can propose a three-parted theory of the formation of custom. And I lightheartedly suggest to you to follow me in a virtual journey from voluntarism to spontaneism with no return. So, in my mind, there are many ways which a customary rule is conceived. First, the classical doctrine, dual structure, which still maintains part of the.
Maybe a bit further away, perhaps that may help. Further away.
Okay. Second, I believe strongly that customary law can be formed through consent states without practice. And third, I believe that customary law can sprout spontaneously from a logical operation of decomposing the interest underlying previous rules of customary law and recomposing this interest in a new rule of customary law. Let's try to make me clear in very few minutes. The classical doctrine, custom slowly emerges over time on the basis of interaction between its dual souls, practice and opinion. sometimes very slowly. Also, the special rapporteur in LC recognized that there are customs which started the process of formation centuries ago and are still in evolution. And this means that states gradually converge toward a behavioral model which proved to be appropriate to the needs of the international community at a given time. Well, James Crawford, as you may know, spoke of customary law or a given day. More modestly, I suggest, for the time being, given time, perhaps some days, or some months, or some years. And so its main functions, contrary to what was recalled this morning as a theory that customary law reflects reality, customary law ensures, first of all, stability. Theoretically, everybody knows, theoretically, there is no rule of change which can explain the evolution of customary law. The famous Kelsenian dilemma. If the first conduct, the first behavior, which are designed to change the law, are in conflict with the law, well, they are unlawful, and therefore the law. So, if we want to remedy such pitfall, we must admit that customary law changes, of course, that change, but imperceptibly and continuously. And the example is given by the classical example of some immunities. You know, a judge, a tribunal of a state make a very small step, and gradually, over time, we have a rule whose content is very different from the rule of many. But there are other ways in which customary rules come into being. The voluntarist model, claim and acquiescence, claim and persistence. There are, and we know very well some examples, there are cases in which states put forward a sudden and violent claim to change the law. And others can acquiesce, and then the law changes. Others can contest, resist, and the law doesn't change. I have the most visible example, which is also the one on which James Crawford founded this idea of customary law at a given day, the Truman Declaration. Truman Declaration, if well known, was an attempt to change the law in expressly terms, or quite. And we have other examples, not only the Truman Declaration. Well, since almost all this conference proposed examples on the use of force, I will follow the Bush National Security Doctrine, which Bush expressly said the self-defense doctrine is obsolete. We must change our course. Of course, whereas the Truman Declaration was quite reasonable, quite moderate, was promptly accepted by the United States. The Bush National Security Doctrine was not accepted. So we can see the two destiny of sudden attempt to change the law. Well, I worked overnight, so prepare the slides. I have no idea what is this third. Okay, let's go on, because also time is running out. But the most interesting example of how customary law can change is according to the third category of process changes: custom and interest balancing. We have a conduct of a state apparently disregarding the law, but this conduct was really based on a decomposition of the previous balance, normative balance, and on a recomposition of the same element, the interest underlying the balance, in a new balance. And the most striking example is, of course, the Torrey-Canyon case. I don't explain why it is not based on state of necessity or other doctrine which are put forward, but there we have the two customary rules which came to play. The exclusive authority of the flag state versus the emerging interest in environmental protection. And the British action which bombed a ship which by an accident was spilling over oil off the port of Cornwall. The British intervention immediately was welcomed as the right solution to a new case, and immediately was called a conference which accepted in a treaty and codified in a treaty the new customary law. But there are other examples. I simply mentioned the 1950 ICJ opinion on reservations, the Genocide Convention, or integrity versus universality in CIL law, and also the fisheries jurisdiction case, and so on and so forth. So, in my view, albeit conceptually different, two last models are based on the notion, but are different notions, different concepts. But the idea, the very idea of conflict, unknown to the classical doctrine. So let's move on. But the ICJ, in a famous case in which dismissed the idea that a conflict between customary rules actually existed, recognized that a conflict among customary rules could exist. In the opinion of the court, however, no such a conflict. Such conflict, namely this particular conflict. And my logical argument is that a customary rule, I never came to accept the idea that customary rules must be found and not be interpreted. For the very same idea that customary rules are rules like the others. Rules like the others enter in dynamic relations with the other rules of the system. And then they can be interpreted and they can conflict each other. Most visibly in the first model I proposed. The Truman Declaration confronts us with an Aristotelic notion of conflict. And here I didn't translate, but I think it's a faithful translation of the logic of Aristotle. While it is possible for X to be actually F and potentially not F, it's impossible for something T for something to be actually F and actually not F. No. And potentially not F. Here I must have mistaken something. It is possibly to be F and not G, but not possibly to be actually F and actually not F. This so must the argument go. And this is precisely the Truman Declaration. But there are other notions. And here I admit that the idea of the ICJ in 2012 that there is no conflict between procedural and substantive rules is simply not accurate. Of course, the outcome I have to point out, because being an Italian, I'm not defending the Italian position. The outcome of the case would not have changed, even admitting that conflict did in fact. But there are others possibly conflict among us. I call this conflict occasional collisions, but I've not invented this kind of conflict. The case law of the European Court of Human Rights, European Court of Justice, the same case law of the Permanent Court of Law and of the ICJ is full of examples of a passionate conflict which the court settled through procedure of process of balancing. And this is precisely the topic. So, ex conflicto jus oritur. We have contentious conflicts and cooperative. Schuman Declaration is a contentious. Be or not to be. Either I change the law or the law remains peace. And that case was successful. In other case, it failed, the Bush Doctrine. But there are other conflict collisions, more properly, cooperative conflict in which all the elements of the rule are there. So the pre-existing rule are in the new law, only in a different balance. And I must not recall that the action of the British Navy was an action which only formally the exclusive authority, rule on the exclusive authority of the flag state on its ship in the high sea. What I fail to understand in this case is why the UK did not make a telephone call to Panama and say, okay, come bomb the ship. No, they acted immediately. But this is, this give me or give the scholarship an excellent opportunity to verify how the law can change suddenly, immediately, instantaneously on the basis of a different balance of the same interest underlying the pre-existing rule. How much time I have? Finished? 1 minute?
2 minutes.
2 minutes? Oh my God. Well, my case study, and this would require much more than 1 minute, but I try to summarize. Let's say that Article 51 has been interpreted by the ICJ. The statement of the ICJ, the finding of the ICJ immediately became new law, in the sense that collective self-defense must be determined by the attack state, and the attack state must authorize other states to act in collective self-defense. This has been made on the basis of a very, I would say, banal logic, intuitive that only the attack state must determine that it was the target of an attack and that it must authorize states to intervene in collective self-defense. Absolutely correct. But if we look at Article 41, the logical system changes. Article 41 of the ASR lay down a collective duty to respond to this collective duty. An aggression is, by definition, a very serious breach of this promise. Well, what is the most appropriate concept? Article 51 or 41? I don't indulge to explain why the lex specialis cannot. If somebody wants me to clarify this point in the debate, I will. Well, the devil is in the detail. Article 51, it is the attack state who determines the modalities. It's the sole responsibility. Article 41, the international community is sole responsible for actions and to put the Cogens breach to an end. And in that case, the aggression to an end. I don't think it is unreasonable to consider that the leading role of the international community fades away precisely in this situation, which can more intensely affect the interests of the international community. Therefore, the collective state responsibility may and should take into consideration other interests other than those of the attack state, which can better secures stability in the international community. So it is not unreasonable that these two aims, this aim of protecting the tech state and the aims of protecting the general interest of the international community may emerge. I don't think it is unreasonable. I don't have any answer, not at all, but this seems to me an example of not only a clash in customary law, also a clash in use Cogens. Both rules have been qualified as part of this Cogens by the ICJ. The last rule, Article 41, in the whole opinion. Of course, one can have doubts. The statement of the court transformed a simple statement of the International Law Commission, devoid of legal effect, into a use Cogens rule. But assuming that it is, well, in my view, it can be not easily, but it can be assumed. Well, this is a clash in use Cogens, which we strive to find an answer, and I stop here, and my apologies for not complying with the time limit, and thank you very much.
Thank you so much, Enzo, for this interesting discussion between change and conflicts in a way. Thanks very much. We had 3 excellent contributions on I think really on top on the topic of the workshop, right? Really helpful to have heard that. The floor is open. First of all, if there's any questions to Enzo Cannizzaro on any clarifications that you need, I would like to give the floor to you to that. Please, Thomas, yes. Oh, sorry.
And so again, on that 41-51 question on that conflict. So the rule breached here is the use of force. So it's illegitimate use of force, and then of course it's up to the state towards the attack is directed. If there should be a collective response, it cannot be against the will of that state. That was maybe the point, that it's that state that has the say on this. And then you have those other rules taken from Article 41 of the Articles on State Responsibility, where it said that states must cooperate to bring to an end that breach of use Cogens, and they must not recognize the consequence. But I don't see the conflict so much.
Well, let's say that the conflict is emerged very visibly, not from a normative viewpoint. Well, I believe that the conflict emerges from an effectual viewpoint, not so much from a normative viewpoint, but from the effectual. It is very easily translated in a normative. Who must take the lead in the defense of Ukraine?
Yeah,
Ukraine or the international community as a whole? Assuming that there is an international community as a whole. This is the problem. The more so, in so much as, we risk the atomic use of atomic weapons, and we must be very careful about it. But let's imagine that the states who support Ukraine tell to Ukraine, well, we support you until the last moment, and so on and so forth. But let's engage in negotiations where, for example, there may be a separation of territories and so on and so forth. Here is a normative conflict between Article 41 and Article 51. It means Article 51 serves the unilateral interest of the attacked state. Article 51 must serve also the interest of the international community as a whole. This is my point. Modest point. Shocking point.
Thank you. I feel that we'll be coming back to this point once you have had some new ideas on this. I'm collecting some questions, and then we'll go back to the panelists for some final remarks. Andre, I saw you. Are there any other ones?
I think if you speak up, people should.
We can see the reaction.
Fuad, can you hear us? You speak up.
Fuad, can you hear us? Can you hear us?
Yes, I can. Yes.
Yeah, can you also hear the audience? We're giving it a try now. Andre.
So, this last point on possible conflict between 51 and 41, I'm not sure it's per se the conflict between 51 and 41. But suppose that Russia had been more successful, that other countries had not been so forthcoming to support Ukraine. Maybe Russia could have taken the four provinces in the east easily and keep it under control. And Ukraine is forced to make a peace, which they recognize, that Russia now has a claim on these eastern provinces. Now, Article 41 is precisely about that kind of situation, because it talks about a response in relation to maintaining the situation caused by a serious breach of human rights. And that would mean that other countries would have a right, even if Ukraine had engaged in the treaty, to actually reject that peace treaty and say, this is actually the result of a serious breach of these Cogens. We're not going to accept it, and we're going to take the formal position that we don't recognize it, and that we will not lend any aid or assistance in maintaining the situation. So no recognition of nationality in those territories, no trade with products originating from those territories, etc., etc. So I don't think it's a self-defense conflict with Article 41. I think it's the result of the aggression in conflict with 41.
Thank you, Andre. I'm collecting a few things. If you, yeah, sure, please go.
Respond immediately because this is a crucial point.
Okay, sure, go ahead.
Well, thank you, Andre. I have not touched the microphone. Thank you, Andre.
I'm very reluctant to explain the conflict between 41 and 51 on the basis of the Ukrainian conflict, because the Ukrainian conflict raises many dilemmas. But just think to the large debate occurring when the question of the Security Council being obliged by youth Cogens. Is the action of the Security Council bound to comply with youth Cogens or not? And the same dilemma presents itself based on Article 41. Is the international community as a whole, or must the international community as a whole comply necessarily with youth Cogens, or in name of security and peace, they may diverge? Occasionally, in a small part, the articulations of the solution might diverge from youth Cogens. Let's imagine. Don't speak about Ukraine. Let's imagine that a solution for Cypher will be found with the agreement of the population and the agreement of the two states in a partition territory. Well, according to youth Cogens, this agreement, if made between Greece and Turkey, would be null and void. Would be null and void also if imposed by the Security Council? I don't know. This is one of the questions which linger in debate on the Security Council powers.
But response.
No, I don't have a response. Just a last remark. The problem is that Article 51 and Article 41 are based on different conceptual needs. And this may lead sooner or later to a conflict. I don't know if in Ukraine, in Cyprus, but they are based on totally different perspectives. The bilateralist perspective, Article 51, the collective or even institutional perspective, Article 41. Well, then I have no answer to give.
Well, just responding, the draft conclusions on use Cogens specifically indicate that potential organizations are bound by use Cogens, including the Security Council. Or some of the bigger states have said, oh, we don't like this, because it undermines possibly the primary responsibility. But that's the first thing. So the draft conclusions actually confirm that international organizations are bound. Secondly, by its own terms, the Security Council must comply with the purposes and principles of the United Nations, of course, which I would argue include the territorial integrity of their members.
Well, I'm not sure. Okay.
No bilateral. A quick response is okay.
No, I'm not sure that the need to comply with the principles of the Charter is equivalent to comply with every single norm of this code. I reflected. Well, I criticized, for example, the Security Council when at the time of Cadiwan, because I don't think the Security Council can infringe human rights, because human rights are part of the principles of the United Nations. But I'm not sure that every articulation of those principles are binding for this group. Not sure.
You wanted to respond to that?
There might be collective principles.
Okay. Yes, please. Next question.
Can I just speak back?
Approach the bench, please.
Can you hear me? Good.
What about now?
Yes, he's nodding. So I had the same question actually about the conflict between 41 and 51, but my two questions now are for Thomas. So I agreed with what you said about the deterrent effects of a use Cogens norm in creating conflicting custom, and that actually this will just inhibit the development of opinion because states would, in practice, accept that a customary norm could exist that derogates from a use Cogens norm. I was wondering if you think there's a similar effect, or it might even be the same effect, if we think about the interpretive effects of use Cogens norm, which is that if a customary norm starts to emerge or emerges that on one view might conflict with the use Cogens norm, might the interpretive effects of that use Cogens norm have the effect that they tend to be interpreted away as not conflicting with the use Cogens norm, which makes, again, so in practice, actually, it's very unlikely you're going to have a use Cogens norm that is invalidated. My second question, you mentioned the withdrawal of opinio juris cogentis by states, and I wasn't quite sure what you meant if that meant that maybe that might cause the acceptance and recognition of its non-derogable status to sort of fall below the threshold required to maintain it being use Cogens, and so it would become just a regular norm. If that is your view, my question is, well, wouldn't that actually require the use Cogens modification threshold to be met? It's not just about falling below the threshold. Actually, really, that's a modification of a use Cogens norm. So to cause a currently use Cogens norm to lose its status, actually, you would need to accept and recognize. Yeah, but maybe that was what you're.
Thanks very much for that question. Do you want to respond immediately since we just introduced that format?
About your first question, yes, I think so. That is why I tried to draw. Yes, I think so. Regarding your first question, yes, I think so. I think that we can draw the parallel between that presumption against conflict as a rule of interpretation and that presumption against change. That is somehow interrelated, and I think somehow aptly rephrased what I wanted to say, or said what I wanted to say. And about that second point, there can be, in theory, a situation that what comes next after a peremptory norm is not a different peremptory norm, but just nothing. So, in theory, we can imagine that the new rule would not be that use of force is prohibited, but that there is no rule anymore on that. And that would be extinction. And of course, that is not modification in the sense obviously meant in Article 53. And my point somehow was to say that Article 53 only covers one type of modification. It doesn't cover informal changes, as I termed it, and it doesn't cover this second mode of of change, of extinction, of ceasing of existence, of the end of the existence of a norm, which in theory would be possible. But there, of course, the other, or this presumption against change would also apply in that case, because to make the claim that there's no opinio juris cogentis anymore, that would also be difficult. It would require that, and then maybe there we can also make the important point that we not only about the evidence of acceptance and recognition, and then you need to think about what it means that states simply remain silent, and you would say then silence doesn't mean so much in that case. Actually, you said that this morning, and I was reminded of that. Of this idea that we would need more than silence if we want to use Cogens norm to be extinguished. Yeah, but in theory, and that's already also an argument made in literature, that this kind of the end of existence of a norm does exist. Yeah.
Thank you. I also noticed Panos first. Christina, yes.
Actually, it was quite ad hoc on the end of the existence of a norm, because obviously we have desuetudo in terms of non-application, but then also and the obsolescence. Well, Austria is quite famous for it when you argue like as an extreme form of clausula rebus sic stantibus, so to say, when the complete context, for instance, of a treaty or a norm disappears, then you don't even need the practice confirming non-use, which can be quite hard. But then you say, okay, and you don't need the formal act of notification of termination, for instance, because just the norm loses so entirely the context that it's gone, like with the enemy state clauses in the UN Charter. To a certain extent.
Very interesting. Sorry to intervene directly, because I had the notion of desuetudo at exactly that point, and then I thought, no, desuetudo is about practice, and I cannot use it there because it's acceptance recognition, and I stuck it out. But that's the idea, yeah.
Thank you, Panos.
I can try and speak loud.
Good.
Yeah. So thank you very much. One question which I think goes to both Thomas and Enzo is connected to what was asked previously was, so we have on Article 20 on use cogens, so the idea that we need to interpret, if we think that there might be some conflict, we need to interpret it in a way that avoids this conflict. So my question is, do you think also that we'll see the tendencies to see also this kind of presumption in favor of interpretation, which was also mentioned by the RCSS? Also referred to on subsequent agreements in practice, so that if we have a question and we're wondering, is this interpretation or modification? And again, here we're using different terms. On the one hand, we use conflict. On the other hand, we use modification, change. It depends on what definition we give. But do you think that this will be the tendency to kind of say, oh, this is interpretation, and we have a presumption in favor of interpretation? And
as opposed to modification.
Of being realistic and saying, well, this is actually modification, and having all the troubles that they can end up with that. So whether you see that in the case of the use cogens, also you see what the RC went for in subsequent agreements in practice. When in doubt, say it's interpretation. And to answer this then goes, does this make any sense? I mean, or should we simply say things, it's conflict, let's be honest, it's not the end of the world, it's a legal system, conflict is going to happen. And to Fuad then, the other question is, because you mentioned the RC's work, maybe you could explain a little bit more, how do you see that? Do you see that their approach should be simply seen as progressive development? Do you think that it will have so much gravitas that it already is, or may in the very near future change situations, or do you actually see that we might end up with fragmented rules of interpretation, depending on the context, depending on the court and tribunal, and so on?
Fuad, perhaps I can try. What?
Sorry, I wasn't able to hear actually. If anyone can summarize the question briefly. Sorry, Panos.
No worries, but this creates a little bit of a problem for me because in theory Greeks are loud, so maybe my passport should be revoked at this point. I'll let you know, Fuad, how that goes. So my question was, because you mentioned the work of the ILC on subsequent agreements and practice and how this kind of stirred up the whole situation with the joint interpretation. So my question is, how do you see that? Do you see that this was a kind of, this still remains in the realm of progressive development on the part of the ILC? Do you think that it already has, or in the near future will essentially be the dominant understanding? Or do we end up with fragmented rules of interpretation? So some courts and tribunals go one way, some others, and depending on the treaties, context, whatever. Thank you.
Thank you so much, Panos. Shall I take this immediately, or?
Yes, please go ahead.
Yeah. So thank you so much, Panos. This is a great point. Actually, you're putting your finger on a very important matter. Now, ILC obviously didn't clarify, whether this was suggested as codification or progressive development. Now, reading between the lines, the special rapporteur's position was that, they are not innovating or they are not putting anything new on the table. This was basically left open by the Commission in 1960s, and they are just clarifying the matter. Now, one question actually that arises is just a few years before that work, you remember ILC also finalized the work on reservations, and there they say the exact opposite. Of course, the special rapporteur here didn't mention it, but it's a little bit strange for the ILC to take conflicting positions on the same matter in the context of, yes, I agree, different works, but still. So I think that matter is still relatively open, whether it's, I think the arguments can be made on both sides, that it may be a progressive development in the sense that we are talking about a matter with respect to which there wasn't, let's say, settled case law or unanimous authorities. So the ILC, in a way, clarified the matter. So it's a possibility. Now, the other point you're making is also incredibly important. Basically, are we going to witness, this rule is going to become the common standard, or are we going to witness a sort of fragmentation? Depending on which regime we are talking about, we will have different responses. Now, I suspect that courts operating in interstate contexts, like the International Court of Justice or the law of the sea tribunal, will be more sensitive to, let's say, classical principle, which was more deferential to joint interpretive agreements, which, by the way, is not something excluded by the International Law Commission's position. The Commission only says it's not necessarily binding. So it's perfectly possible for the tribunals operating in interstate context to say that they are binding in this particular context. But where things might differ is with respect to what is usually called, I think it's a nice terminology, treaties with third-party beneficiaries, basically human rights treaties and investment treaties, for instance. I find it interesting, for instance, you may have observed the same thing, Panos. For instance, each time the Human Rights Committee prepares a general comment, a draft, that draft is submitted for comments to literally every human being in the world. Nothing is required. No legal qualification, no position with the government, no academic degree. Everyone is free to provide their opinion. And probably, I assume, presumably, the assumption is it's a human rights treaties. Everyone has a stake and has a say. The same with investment treaties. There is a trend suggesting that giving a dispositive effect to joint interpretive agreements might be undermining the due process and equality of the parties, because as we know, the investors, basically the side that has the possibility to trigger arbitrations are not in a position to be a party to a treaty or to an interpretive agreement. So basically, there is a fear that states might actually abuse this power of interpretation to, in effect, rewrite treaties instead of engaging in a genuine interpretive exercise. But I think it's an exciting matter and to be followed. I think it's something we have to watch carefully to see what happens.
Thank you, Fuad. Final comments.
Yeah, thank you. On your point about the relationship with, or maybe there might be a presumption, well, I think there's a presumption or a pro-interpretation contra modification. I think I have no say on that. I think that what I was talking about was the deterrent effect of use Cogens, which has influence on both its contra modification or against change and it's against conflict on the level of interpretation. On a different note, of course, there is an interaction between modification and interpretation. The threshold for modification being so high is maybe the reason why we need other modes that provide for change. But this, of course, depends on who is in the position to make the modification. If it's the states, yeah, if it's other actors that have these other modes of change, that is interpretation, that can also be causes. But I haven't thought about what we're talking about. So the simple answer is I have nothing to say on that. Sorry.
Thank you very much, Enzo.
Well, the difference between interpretation and change for modification.
Modification, yeah.
Modification was dealt with by Thomas. In my view, well, my answer is a bit trivial, but this way I don't have a normative doctrine for the difference between interpretation and conflict. But also in the case law of the ECJ, we can find a plausible answer. For example, in Nicaragua, 84, not 86, the court, always with reference to the self-defense, interpreted the rule of self-defense. Said there is no practice. Well, in fact, said there is no law, but okay, it's not the same thing. But for sake of of brevity, let's say there is no practice, and therefore the attack state and so on and so forth. So this is interpretation. This is draw from a rule the most logical meaning in this specific case, whereas conflict involved a plurality of rules, and there are many categories of conflicts. I simply refer to conflicts which are direct, Aristotelic, and those who are indirect, they call them collisions. It's a very trivial classification. But conflict, by definition, by nature, must involve a plurality of rules which clash or collide.
I would have a question for Enzo. And I would like to return to your distinction between these three types of development of customer international. And there was one first example was contention plus or claim and acquiescence, claim and resistance.
It's the same.
And that's the same. And then you had the other example that was cooperative collision. And the first one were examples for the contentious collision. But if you have claim and acquiescence, why is that contentious? That was the Truman proposition.
Because it was aimed at because the claim was aimed at change the law. Simply that. Contentious. Ambitious to change the law, and then it may fail or successful. This is my scheme.
Yeah. Okay. So it's the ambition of the actor that sets the new, tries to set a new. And the second example, that does such an ambition doesn't exist. Okay. And what is the role of very, very big question? What's the role of reciprocity in all that? Does it play a role in all these forms of change, also in that cooperative form, where you have the balancing of interest? Is that also reciprocity, or is that something different? Because that claim of acquiescence and claim plus resistance, that's very much in that reciprocity scheme of thinking, by Simmer, mainly, yeah? So.
The question is much more sophisticated than the answer. It's a German mind who asks the question. It's an Italian mind who takes the response. Please consider that I haven't written anything on this subject apart a very short introduction of a book written in 2004. And then I wanted to write a book on that topic. I never did. I never found the time. And therefore, it remains in my mind, which is not so tidy as yours or so precise. But this is my answer. Reciprocity. Reciprocity. I never thought about reciprocity having read the book by Bruno Simmer, but never thought of reciprocity, the role of reciprocity in such a context. Reciprocity can well have a role in the contentious, because of course the cost of states immediately accepted the proposal of Truman. But the others, what about the others? The others had no reciprocity at all. And nonetheless, the rule emerged. Well, so I don't know. And reciprocity may have a lesser role, but a role nonetheless, also in the Torricanian, because other states immediately followed the example to protect their own coast. And the flag states did not raise much protest, possibly because they believed these things was reasonable. And I asked you rhetorically, I never understood why how do you call the Minister of Foreign Affairs of the UK did not make a telephone call asking the permission to intervene. Was the simplest solution for the dilemma, but still. Let's close in a light tone.
Thanks very much, Enzo. We have reached the end of this afternoon panel. Thanks very much to all the participants. I think the themes were very fundamental. I mean, it's the red line thread seems to be something on the tension between continuity and change, or stability and change in the TRICI-Law project is, I think, a general theme that you address, Panos. Thanks very much, and please join me in thanking once more our three excellent panelists. And I gladly hand over back, I should say, to any of the two organizers.
No, maybe? All good? Perfect. So there is a dilemma every time we come to this stage of the proceedings. Do you go for a synthesis, a summary, or for a polemic? And I guess, it depends on the mood of the dinner. Should it be a happy one, a more lively one? Well, I guess we shouldn't go for, anything bad today. And I guess all presentations actually, there is no, what all presentations have proven is that there is no single way to think about change in international law. Even a strictly formalist approach needs to take into account that the rules of change are themselves the product of progressive development and elucidation. On the other hand, the idea of authority and people who take the opposite view that, rules relating to change are unnecessary and they would, are incurably, doomed from the outset. Also, can readily accept that all claims to authority come back to certain propositions that either define the legal profession, either define the, the framework of change in international law. Now, in this sense, we have tried to, draw the framework of analysis, be that rules of change or changing rules, it's up to you to decide. Of course, we have identified a few things, that the law of the treaties has a more detailed framework addressing different juridical operations to a certain extent. How do you create a treaty, modify a treaty, how do you interpret the treaty, what are what is the relationship between the law of treaties and the law and other rules of international law, especially law of responsibility. And we have identified also the problems in the theories of unwritten international law with respect to use Cogens, the issue of virtual, immutability, although in theory it is changing, and we have seen the different aspects of this change. And with respect to customary international law, this idea of constant flux, which paradoxically, through this flux, also you can see that, conflicts arise. Perhaps it's a paradox to me. In any case, change is going, I think, to continue to, call for further reflection. And with that in mind, perhaps we should, foreshadow the fact that the ultimate goal of this workshop is a publication, a series of brief and sort of impressionistic essays on change in the separate fields identified in the workshop. And we hope that we can discuss about it over dinner and conclude, on the general idea of that special issue. On behalf of the entire TRICI-Law team, Nina Mileva, Marina Fortuna, and also Elena Kukovica, and Mikol Asael, who is also part of the team for today. We'd like to thank you all for attending, and we hope to see you again soon for some time in the future. Thanks very much.